Registry Matters is an independent production. The opinions and ideas here are that of the hosts and do not reflect the opinions of any other organization. If you have a problem with these thoughts, FYP. Hey, just a quick little note about tonight's show is that there were lots of technical problems that went on on my end and on the guest's end. And so this is, everything seems to have come together okay, but just wanted to warn you that some audio challenges exist and the guest switches from a pretty high quality setup to just using the telephone. But just to give you a heads up. Recording live from FYP Studios East and West. Transmitting across the internet, this is episode 148 of Registry Matters. Larry, someone in chat just a second ago, apparently I forgot to feed the gremlins because they're angry and everything that could possibly go wrong has gone wrong tonight.
It's a plot by the authorities. They are trying to put registry matters off the air.
This could be true, man. This could totally be true. Well, what do we have going on tonight?
Well, we have an interview coming up later with our special guest, Ashley Reymore-Cloud, a defense attorney from the state of New Mexico. We have a couple of listener questions, and we're going to zip through some articles that shouldn't take a whole lot of time. So let's roll.
All right. Well, we will certainly get the ball rolling quickly. The first article, let's see, we'd already did those questions. First article that we have comes from the Crime Report. Could pandemic jail reforms turn permanent in Colorado? Which then we also have a companion article that talks about something very similar, except for not quite the same thing in California. What's going on here with these two things?
Well, in Colorado, in Arapahoe County, which is a suburban Denver county, they've reduced the jail population, and they have acknowledged that the doomsday scenarios did not materialize, and that they may want to keep doing business this way because it's more efficient and less expensive. So, congratulations to the ACLU and to the officials in Arapahoe County. And unfortunately, that's not the same thing happening in California. There's a law enforcement initiative in California, which is our next article, that they want to roll back recent reforms because it's just not feeding the system the number of people it needs to sustain itself. So they're going the opposite direction, but it's underwritten by the police. What an amazing surprise!
But I don't think of, if we were to like pigeonhole these things into team left or team right, I wouldn't call Colorado like a bastion of leftism, but I would definitely call California that. It would seem that California would be all over having these things become permanent, and maybe less so for Colorado, but this is coming out kind of the opposite way.
But you have the wild card that California has the initiative process that can cause bad things to pass by voter, and you use the emotion of the moment, which since the pandemic and all the rhetoric about the tidal wave of crime and the law and disorder, lack of law and order, it's a great time to scare people and to get people to vote. So this is Proposition 20 that if it's passed will undo previous reforms. And the thing is, it's underwritten by the conservatives, by companies, and by law enforcement. I mean, I'm just reading from the article. It's one of those things where you really can't judge the politics of California so much by who they elect, because they have a process that bypasses that, and they can do it directly by going through the voters. And the voters are not necessarily the best informed.
So, Larry, something that I was going to bring up, though, is that Costco, you were talking about different companies that are supporting or not supporting, that they have pulled out of this Proposition 20's passage, and they were asking for a refund of their $50,000.
Yeah, I noticed that, but the major donors of this are a police union, a political action committee benefiting Republican Representative Devin Nunes of California, and an energy corporation, and several large grocery chains like Safeway, Costco, Ralph's have collectively donated hundreds of thousands of dollars to promote the initiative, which means PR, advertising, and Costco has pulled its support, and they want their $50,000 back. But this is something where the voters will vote based on emotion of the moment, because if there's enough fear about the tidal wave of crime, and the police are telling you if you do this, you'll be safer, it's very tempting to vote for this.
Right. Yeah, it's all about keeping the fear, the impression that this is going to keep you safe. Larry, we are joined by a very special guest this week, Ashley Reymore-Cloud. Ashley has been with us before, 4, 5, 6 times. Ashley is a former assistant district attorney for the 13th Judicial District Attorney's Office who left last year to pursue criminal defense work, specializing in PFR cases. She spent the better part of her 25-year legal career as a prosecutor in New Mexico. She's one of those people, Larry. As a prosecutor, she has also held positions as felony DWI supervisor, arson division supervisor, and supervisor of the DA clinical program. During her time at the 2nd and 13th Judicial District Attorney's Offices, Ashley has prosecuted and tried numerous cases including child sex crimes, murder, property crimes, drug crimes, domestic violence, escape from jail, arson, and DWIs. In addition, she has extensive technology experience in forensics, cybersecurity, knowledge management, and e-discovery as a consultant for law firms and working for various software companies. Welcome back, Ashley. How are you tonight?
It's great to be back. Thank you for having me again.
We can set this up. Ashley has just tried a case that involved sexual accusations in district court here in Bernalillo County, which is Albuquerque, and it resulted in an acquittal. So we're going to do a somewhat deep dive into the results of that trial, the nuances of that trial. And I want to begin by congratulating Ashley with the many dozens of congratulatory messages that she's received from her colleagues in the Defense Lawyers Association. For those who were skeptical if she actually does defend people or if she's a sellout, I think that this would be one of those where when you look at what the person was facing, which we'll get into, and the result of what now he's facing, it's a spectacular outcome. And it's those who say that if lawyers would try more cases, we'd have more of these. We're going to go into that and explain why that's not necessarily true. But first of all, we had a listener question. If Ashley's back, I'd like to do the listener question before we start going into this.
Excellent. Okay, so first question is, hello, my name is Michael from South Carolina, and I have a question for Larry and Ashley regarding the Fourth Amendment. If you are on supervision, but also reside with someone or family who isn't, can they disregard the Fourth Amendment rights of the family members? Also in that same situation, can they legally tell my family members not on supervision not to put up any Halloween displays? Hey, it's that time of year, Larry.
Great question. Ashley, go first if you like.
So I'm going to resort to Larry's stock answer, which is they can until they're made to stop. Technically, can they do it? No. Do they do it? Yes. Do they do it all the time? And have we challenged it? Yes. And Larry, I'm going to let you just jump right into that.
I agree with that. They can do almost anything until they're stopped. And what stops them is either the courts, and sometimes that doesn't even work when they lose, or their own morality. But in terms of when you're living with a person and they have approved that residence, one of the conditions they have is they want unlimited access, unferreted, I think is their terminology, unferreted access. So what they would do if they didn't have unferreted access would be, we want unfettered access to this. What they would do is they would say this is no longer an approvable residence, and then you'd have to challenge that. But they would say, since you're impeding us from doing our job, that we will say that this residence is not appropriate for you. And then you find yourself in court fighting about what is unfettered access, not unferreted.
I like unferreted.
I know. Does this have anything to do with small animals?
It does.
Oh, well, that's a sign of old timers right there. What or I was thinking about your animals. But
that was a Larryism. That was awesome.
Yeah, pretty good. But yeah, if they tell you that your residence is no longer deemed appropriate, then what's the next step, Ashley? They tell you got 24 hours, 48 hours, 72 hours to find another place. What happens next?
Then the next thing you do is you take that before the judge on your probation, assuming you're not under an interstate compact, which is a whole other situation. But you take that before the judge, your sentencing judge, and you ask for a clarification on your conditions of release. Or your probation conditions.
If you're on parole, that presents a different type of issue for you because you're under a board of authority versus the court. And if you were to take the thing into court, most courts would do their best to duck it. Some wouldn't, but most would figure that was an administrative issue for the parole authorities to determine, and they would do their best to duck out of that.
So they can tell you that we didn't have a problem with you living here, but because of Halloween decorations, because maybe the person, they do things that they don't like, they can then say, you can't live here.
That's not only what they can do, that's what they do. They tell people that if the household, see, the household's not under supervision, they can't give any orders to the household members. But they tell them that if the household won't cooperate with your rules, then this household is not appropriate for you. And without cooperation from the household members, it's like the thing of the Second Amendment, you have every right to own a weapon. But they say we don't want any weapons in the house for our safety. Well, they can't preclude you from having the non-supervised person from having the weapon if they're not a convicted felon. But they can tell you that you're not going to live there because we're not going to go to a place that has weapons everywhere.
Do they have some level of compassion about it, of if like the room could be, not necessarily for the gun thing, I have a feeling that would be almost like something that you couldn't get past, but other things, could they, hey, if you lock off this room, maybe there's a computer in the room, just as an example. If you don't have passwords to it, will they like give you a buy?
Did you just use compassion and probation and parole in the same sentence?
I did, and I breathed even breath. I took a breath there as well. So is that a negative? Like, no, they're not going to do it?
That's a negative. Yep, that is a negative.
Are you speaking specifically from the state of the New Mexico, or is that what your collective experience is across the country?
New Mexico and Georgia, but Georgia was not nearly as bad about that stuff as New Mexico is. New Mexico is horrible about it. They don't care who in the house. They don't care if it's face recognition software and you can't ever even get into that computer. They want, as Larry put it, unferreted access.
Now you're going to really mess up our spell checker trying to figure out how to. We got ferreted so many times, and he's going to have a real problem with that with the transcript.
Make him earn his keep. That's all I say.
Well, especially with what he's getting paid. So, yeah, the short answer is yes, they can, and you're in for a fight if you don't like the fact that they impose these conditions on the household members, and they do it indirectly because they cannot give them direct orders. They merely give them orders through you. You have to tell your household member, I'm not allowed to have these things where I reside. And if the household members are not willing to give up those things, they have every right to do that. But then they will tell you this residence is no longer approved.
Well, that sucks.
What?
Go ahead, Ashley.
No, I was just going to say that we've seen that actually not just in New Mexico and Georgia. We also saw in Illinois where if a family member had a dog and they didn't want to approve the house for the family member having a pet or having a smartphone, they wouldn't approve it for parole.
So it sucks, Andy, but that's the way it is. That's the way it is. I haven't used that for a while.
But this is hyper state specific based on how your handlers are going to be in that specific state. Some states are significantly more aggressive than other states. I mean, just the comparison in New Mexico and Georgia, where I know people that have multiple PFRs under the same roof, where, Larry, you have said that would absolutely 100% not happen in New Mexico. And so your mileage may vary based on where you are.
Yes.
You're absolutely right. Absolutely right. They would never put two, unless it were a husband and wife, spouses. It doesn't have to be husband. It could be husband and husband these days. But unless it's spouses, they're not going to put two PFRs under the same. They're just not going to happen here.
And even then, they would try and break up the spouses. We've seen that, right, Larry?
That was my next question. Are they going to intervene into relationships that they may deem like? I mean, short of it being an illegal relationship, let's just say they have some sort of personal vendetta against the opposite person. They can then step in and go, there's nothing really wrong with that person, but we don't like them. I know it starts to get sketchy, but they could do that too?
Yes.
That's not cool.
All right. We'll move on. Number 2.
All right. So there's a case that you guys are going to bat around, and I'm going to sit back and listen.
No, we had a question.
Oh, we're going to do question number 2 first?
Yes. That was the question I actually wanted to do.
Oh, okay. Oh, my bad. All right. Well, then here's question number 2. It says, look, I don't know how many times I've been asked this, but I still don't understand. So I hope you people will try to simplify the answer. Larry utters that legal mumbo jumbo, and some of us need to be explained in simple terms. I am on an interstate compact in Georgia, and my conviction is from Joyzy. I had community supervision for life in Joyzy. Larry pontificates that the state of conviction controls the punishment, yet Georgia requires so much that New Jersey did not. Georgia has exclusion zones where PFRs cannot live or be present, and New Jersey did not. Also, I have a curfew in Georgia, and my CSL in Jersey did not. Does Larry know what the hell he is talking about, or does he just make this shit up as he goes? And I have embellished that because I wanted to.
I was going to say, as much as I'd love to say that Larry makes this shit up, he doesn't. He actually knows what he's talking about. The Interstate Compact, oddly enough, was a bunch of states getting together and saying, okay, we'll take your person on probation or parole from your state, but we're going to put some conditions on it. And our conditions, if you don't like them, then don't send your probation or parolee. And the other state said, okay, fine, we're going to do the same thing. And next thing you know, under the Interstate Compact, that's how it is. So the sending state controls whether or not you get actually truly revocated. However, the supervising state, which in this case would be Georgia, gets to set whatever conditions they want. And if you don't like it, you just go back to your sending state. Right, Larry?
That's mostly the way it goes. And I would say the exception would be if there were a clear-cut constitutional violation and you wanted to litigate that clear-cut constitutional violation, and if you could find a court that would actually receive your complaint, which is proven extremely problematic for those of us who've wanted to litigate these issues, you might be able to have the constitutional violation challenged. But simply having an exclusion zone, those exclusion zones have largely been upheld. So that, while you're under supervision, all those have largely been upheld for a supervised offender. So you're probably not going to get a lot of traction on challenging an exclusionary zone while under supervision. But what confuses him probably more is that Georgia has exclusion zones that are part of the registry, depending on your key dates of when your offense occurred. And the band of exclusions gets greater and greater the more recent your conviction. The older the conviction, there either is no exclusions or there's like maybe just schools. And then the more recent the conviction. So he has to deal with figuring out what registry exclusions he has as being a registered person in Georgia. And then he has to figure out what supervision conditions Georgia has added to his CSL that he didn't have in Jersey, and whether or not he actually has a constitutional issue. Not liking it isn't a constitutional violation. And that's hard for people to comprehend. I didn't have to do this in Jersey does not make that a constitutional violation in Georgia. Ashley, do you agree with that?
I completely agree with that. And the other thing about it is that what it says under the Interstate Compact and what the sending state agrees to is as long as they are enforcing those same conditions among similar people. So the existing people on probation or parole in Georgia are getting the same conditions as the person that they send, i.e. those exclusion zones, then it's been upheld across the board.
Absolutely. And therefore, I would encourage anybody in this, doesn't be this particular person, but anybody who's in this condition where they have additional restrictions imposed in a receiving state, to think very hard about whether you want to sink a bunch of money into litigation, because it's going to be expensive. They have unlimited resources, and they're not going to want you to set a precedent that people coming from out of state can set their own terms of supervision. what you want to do when you go to another state, you want the exact sentence to follow you, and it does in terms of duration. But in terms of how they effectuate that sentence, the same thing would be if they interstate compacted you to serve your prison time. If you went from a really progressive state and they had shortage of bed space, and if Vermont had to farm you out, which that is one of the states that does farm people out under state compact, and you get to Alabama and you tell the people in Alabama that when you're serving your prison time, that when I was in Vermont, I had this list of privileges, and you show them your Vermont prison handbook, they do not care about that prison handbook for Vermont. You're not in Vermont. And you will be incarcerated and wear the uniforms, and you will have the privileges that the Alabama Department of Corrections give you. And that's the same thing under supervision. You will have the privileges, if any, that the state where you're being supervised affords to you while you're being punished. And if they are not doing any extra conditions to thwart the spirit of the compact, if they just put those conditions on you individually, you have a complaint. But if those are standard conditions, as Ashley said, if they're consistent with how they supervise their in-state convicted people, there's very little a court's going to do about it. But you can sink a bunch of money into it if you like. But it would probably not be the best investment of capital.
Right.
I just wanted to throw out and clarify a couple terms we use. CSL, and that's Community Supervision for Life, and PFRs are persons forced to register. Somebody suggested that we start using that term, but I like it. It's my most favorite.
It's one of our listeners' suggestions, and it fits, and we probably ought to do it regularly because new listeners come in and they don't know what a PFR is.
Teresa says she loves it.
Okay. So Ashley, we just had a little technical issue that we think we got resolved, so let's try it again. Congratulations on this magnificent victory that you had in the 2nd Judicial District, which is Albuquerque, Bernalillo County, New Mexico, on some significant sexual charges, allegations. I don't know the specifics of your case. All I know is that we talked about it and you were stressing about it. Going to trial, and the client insisted on going to trial because he wasn't going to make no deal, and you had what you thought was a very good plea offer, and took it to the client. The client said, "No way, Jose, not taking that." So you took it to trial. You had a jury verdict, and the juries can take days, hours, a different amount of times. How long was your jury out on this case?
So my jury was out over the course of 2 days, almost 7 hours. But to back up, there was no good plea deal because I even went to a settlement conference, and unless they were going to drop the sex offenses, I refused to take a plea, and my client refused to take a plea. Now, what he did absolutely insist on, even though the judge tried to give us multiple continuances based on the pandemic and several other things that happened, my client would not accept a continuance. So we went ahead and we tried the case in the middle of this pandemic, and it was worth it. But they were out a little over 7 hours, and it wasn't even on those sex charges.
Wow. Well, let's be specific. What can you tell us about the charges? What were the charges? And when you use the abbreviations, try to explain what that means. And then when I get to charges, I want you to tell us how much exposure he was facing. And by exposure, I mean if all counts had been convictions, and sentences had been imposed consecutively, how much was the exposure that the court would have had available to it? So what was he charged with, and how much exposure was he facing?
So when we started the trial, he was facing 2 counts of criminal sexual penetration with personal injury and 1 count of criminal sexual contact, then an aggravated battery charge with great bodily harm, and 2 misdemeanor batteries. If all of those had run consecutive and he would have been maxed out on him, he was facing almost 25 years, and he was also facing indeterminate parole on the criminal sexual penetrations and the criminal sexual contact. And that's what we started with. Okay, and then when you got your jury verdict, what did you end up with in terms of convictions, if anything? So the criminal sexual contact and 2 of the battery charges, I had directed verdict out, which meant that after the state put on their case, there was not enough evidence for it to even reach the jury. So all we were left with going to the jury were 2 counts of criminal sexual penetration and the aggravated battery, great bodily harm. And then I got in an intoxication defense. By the time everything was said and done, he was convicted of the aggravated battery, great bodily harm, and he faces a 3-year exposure.
So he went from 25 to 3.
Yes.
And I think you told me you had made an offer to the state, even though they didn't make an offer. And what did you offer to try to resolve the case? Do you mind saying?
Sure. I offered them the aggravated battery and to stack the batteries, and then he had another outstanding case on something completely unrelated. I offered to give them 9 years of jurisdiction, but I would not take a plea to the criminal sexual penetrations and the criminal sexual contact. I would have pled. We could have come up with other charges, alternatives, and I would have given them that kind of jurisdiction, but absolutely no, in no uncertain terms were we taking a plea to the criminal sexual penetration.
Well, that leads to my next question, because of, we got 10,000 listeners out there, and a significant number of them regret having entered into plea agreements with the state. They have what we talk about as buyer's remorse. I should have gone to trial. So we're going to try to unpack about rolling the dice and going to trial. And since you've been on both sides as a prosecutor and now as a defense attorney, you can probably unpack this better than anybody. And so I want to go through some various components of what you evaluate. And I kind of went through my ideas of how a case would be analyzed. When I'm consulting with attorneys, these are the things that I know we're looking at. But you can just work off of my list, or you can go from your own. But I'd like to unpack what if everybody. Well, this is the first question. Well, if everybody would just go to trial, the system would crash. What's the answer to that? If everybody went to trial, what would happen?
Oh, it'd be impossible. If everybody went to trials, people would be sitting in jail waiting for trial, especially because here we do what's called a pretrial detention, and we hold people until their trial. And they would be sitting in jail for years and years and years. Just even trying to do a couple of trials, they're having to bring in other judges here right now. So it's not feasible that everything go to trial. But if a case is close, or there's a good defense, or you've got nothing to lose. Let's say they make an egregious plea offer and they're offering you 9 years, and you're like, you know what, I'll roll the dice. I could get that after a trial. Then roll the dice, go to trial. So,
well, you chose to roll the dice where there was considerable exposure here. So let's go through some of these factors that you that, like I said, I know that when I'm consulting, we evaluate the strength of the prosecution's case. What does that mean when you're evaluating the strength of the we look at the elements that they have to prove and the strength of their case if they can prove this. Explain that to the audience. What do we mean by that?
Sure. So when you're evaluating the strength of the prosecution's case, and in this case, I'll use a few specific examples. I interviewed the complaining witness. I interviewed another person that had a recording of some of the actual incident. I interviewed the officers and, of course, the person who had done the physical exam on the complaining witness. And then I flat out told the prosecutor at that point, I said, you have problems with your case. And the prosecutor's response was, there's problems with every case. And I said, okay, let's go to trial and see how big your problems are. So that was part of evaluating the strength of the prosecution's case. In my mind, it was a 50-50. It could go either way, and it was going to be a he said, she said case, which we'll talk about a little later. But that was enough for me to roll the dice. There's different percentages and different attorneys. In fact, the attorney that had it before me, not to call him out, wrote the notes when he transferred the case to me saying basically it was going to lose if we went to jury trial. And I just didn't believe that. So it does depend on the attorney as well.
Okay, now you said you interviewed witnesses. Now that's not an option available in some jurisdictions, but you did do that. What did you determine in terms of the credibility? When we talk about credibility, as in my mind, we're talking about how well they're going to testify, how believable they're going to sound. What did you determine in terms of credibility of the witness that would be the primary witness at trial? What was your analysis?
I believe she wasn't credible. I believe that she was either lying or mistaken about some really weird things, which made me not believe the rest of her story. And it was stuff that was kind of common sense. And I figured if I put her in front of a jury, or if the state put her in front of a jury, that they weren't going to believe her either. And they didn't. They flat out didn't believe her. And
okay, so we've got credibility as an issue. what happens? How is that hindered if the person, in the course of investigation, if the accused has made a statement to the police and they've signed a statement, and particularly if they've been Mirandized, would you have had the same outcome? Or in fact, since I don't know the details of the case, did your client make a statement to the police, and did you have to overcome a confession?
Oh boy, did my client make a statement to the police. So part of the state's case and what they rested on was an hour long, and I wouldn't even call it an interrogation. It was basically my client spewing stuff to a police officer after he had been arrested, voluntarily talking to him and telling him everything under the sun. However, in my case, from the start, he said it was consensual sex. So, and then he didn't talk about the fact that he beat her up. So what we really had to overcome was whether the jury believed that it was consensual sex, and also that he didn't tell the officer that he beat her up, which we were saying in trial he did. So I had to walk a very, very fine line on that statement and determine how we were going to proceed and how we were going to address those issues. But from the start, my client made a very big statement, and I told him, I said, if you're ever in this situation again, don't talk.
Well, assuming that it was not he said, she said, but and not only was it not he said, she said, the issue of whether the sex occurred was not in question. It was whether it was consensual or not. But say the issue had been whether the sex was non-consensual and your client had made a statement. Wouldn't that have almost sunk your case?
Yes, it would have. Because our whole defense was that it was consensual, and the battery, the fact that he beat her happened after, and we had an explanation for it. But if he would have made a statement and said, no, I pulled her out of the car, she was saying he pulled her out of the car, tackled her, and then raped her. He was saying, no, we had sex in the car after they had just met and they were drinking, and then she did some things that caused him to black out and he beat her. And that was the version that the jury actually ended up believing. But if it wouldn't have been for that, and there would have been more evidence and she would have been more credible, and then my client made a statement and said, yes, I pulled her out of the car and I raped her, it would have been a whole different ballgame.
So those listeners out there, many of them are already past that point. But making a statement when you have two different outcomes on a case, and what we're trying to illustrate here is that just simply having the courage to go to trial is not all the considerations. We're going to get into more. But oftentimes your case is sunk by actions that you've taken. And so had he made a statement, what would you have done in terms of trying to suppress that? And how viable would a motion to suppress have been?
So actually in this case, the prior defense attorney made a motion to suppress that statement because he felt it was very damaging. I saw it a little bit differently, but he did make a motion to suppress and it was denied. Even though my client was in custody and sitting in a jail cell when the officer questioned him, the problem was that he voluntarily made that statement, and he videotaped him, and he talked to him and gave him all those, and he never stopped talking to the officer.
Okay, so a motion to suppress, a point we're making is they're difficult to have granted, and you really have to climb up a long rope to get a suppression granted, and so it's better not to make the statement than to put your lawyer into the position of trying to suppress a statement that you've made. And when you consider going to trial, what considerations do you make in terms of the jury, potential jury, the pool? Do you look at the intelligence level, the sophistication level, or are all jurors all the same? If you're in Clovis, New Mexico, are you going to get the same type of jury you're going to get here in Bernalillo County?
No, definitely not. Completely depends on where you're at. So the makeup of potential jury, we were really worried about because of the pandemic, because you don't get the same jury makeup that you do before COVID-19 happened. And we sent out special questionnaires about whether people could wear masks for 5 days, which we believe the trial was going to take. If there were other special questions about if they had ever been abused or if they knew somebody that had been abused and things like that. So right off the bat, we struck 20 of the potential jurors before we ever got to court. The state and I sat down and just struck them. The with regards to just general jury makeup, down in Clovis, it might have been a different outcome. Here, I figured we at least had a 50-50 shot. Up north, no telling, and then Georgia juries, no telling. What I was banking on was that they were going to hate the complaining witness so much because she got into a car with somebody she didn't know and drank with them, went around the corner and drank, and then stuff happened, that they might actually blame her and believe that she brought this on herself, if in fact they believe the sex was non-consensual.
So, when you're analyzing going to trial, we've talked about the jury, the makeup. What about the judge? New Mexico is one of the few states that I think, and maybe the only state I'm aware of, where you can excuse a judge. The defendant can do that. And would you make a different decision if you had retired Judge Ross Sanchez or someone like Ross versus you had Judge Brown, who was a former prosecutor and is a very well-respected jurist? Does that play into to go into trial, who they're going to be trying the case before?
So in normal times it does, but New Mexico, as soon as the pandemic hit, the Chief Supreme Court Justice here did away with our ability to excuse judges. So that knocked out that you can't even do a little bit of forum shopping. Neither side can. The other thing is, because of the way they're now splitting up the jury trials, the assigned judge may not even be the one that actually tries it. They just pan it out. So even if you've been dealing with, let's say, Judge Brown all this time, by the time we get to trial, we didn't know who the judge was actually going to be, but we had already committed to go to trial on it. So in normal times, yes, I do consider who the judge is and what kind of rulings they'll make. However, we don't have that luxury anymore, and we just had to roll the dice and just hope for the best.
And you ended up, you've been practicing long enough. I could name some judges that you would not have wanted to have tried this case before.
Yes.
Yes. And I don't think it would serve any purpose to do that. But the point is that a good attorney, a good legal team, you're going to look at a plethora of considerations, and if a case is high profile, and I don't know if this one was, but if a case is high profile, what does that do to the equation and analysis of how that case is going to play out?
So it's funny that you asked that, because this case wasn't particularly high profile. It might have gotten a blurb in the news somewhere along the line, but it wasn't big high profile like one that I have coming up in the next month or so. And we're going to have to quiz the jury a lot differently. In this one, Judge Brown asked the jurors if they had heard about it, read about it, anything like that. You may have to do a change of venue if there's too much publicity. We actually, in the other case, had to do a gag order against the state in 2 different jurisdictions because they were going to the press on everything in that other case, and they were going to taint the jury. So it is a big consideration if it's a high-profile case. Plus, if you have a judge that isn't nearing retirement, or you have a judge that's up for re-election, those high-profile cases tend to make them make different rulings. It shouldn't, but they do, because they're concerned about how the public's going to view them if they go easy or they make a ruling that's unpopular and the state goes to the press. So there's a lot to consider in a high-profile case.
And doesn't the state generally allocate a little more resources to a high-profile case because their reputation as a prosecutorial entity is also on the line? My observations have been that they find a way to channel more resources to those cases. You were in that side of the equation. Did that happen in your office? Did you get more? Did you receive more resources in a high-profile case?
Yes, actually I did. And in that other high-profile case, it's exactly what you're saying. I went in to go do a hearing, and there was me and my client. There was an entire packed courtroom with the press and everything, and there were no less than 5 prosecutors from 2 different agencies and their bosses on the other side trying to fight the motion against me. So they do. They absolutely pour resources into it. They pay a lot more. It's an uphill battle. So,
let's talk about this jury. They were out 7 hours, and they weren't talking entirely about the sex. What was the makeup of the jury? I think when we had our conversation prior to recording, you told me that it was a really surprising makeup. So describe the jury. What did you get?
So in 25 years that I've been doing jury trials, and I've done hundreds of jury trials, the average age of the juror is somewhere between 45 to 65, depending on which part of the state you're in. This jury, we only had 3 people over the age of 40, and everybody else was younger than 30, with the exception of like 2 people who were in their early 30s. And when we picked the jury, we basically did it on the questions and everything, and the average age of the jurors were right around 25, which was really shocking, but they did a great job. And it turned out the foreman that they picked was not one of the older people that I expected it to be. It was actually, the foreman was about 23.
And I know that sometimes their interaction with the jury after the verdict. And did you consider this to be a very intelligent jury compared to? I mean, I've seen some doozy juries that people have had to be before. What was?
I have to.
What was? And that is so important. You really need to consider that if you're in a farming community, a small community, where that's all they've done all their life, and very few people have anything more than a high school or less education, they are going to be predisposed to believe what the experts are telling them, and they're not going to feel that they have the expertise to combat. And they're going to say, well, if they say they've done it, I reckon they've done it. And you would need to consider that when you're making your decision to go to trial, would you not?
Yes, and in fact, we asked, both the state asked, I asked, and the state was in a worse position than I was on this question, but asking them, how much evidence are you actually going to need? And overwhelmingly, they were like, it isn't enough for the complaining witness to testify. It isn't enough for us to hear an officer testify. We want scientific evidence. We want other evidence. We want physical evidence. We want a lot before we're going to convict somebody. And they said that unanimously in voir dire. So I was pretty happy that they were holding it to that standard and not the, well, they're here, so they've done it standard.
Would you just briefly use that term, voir dire? Would you explain what that means to people that have never done a trial?
Sure. Voir dire is the French for to speak. And what it really means, okay, both lawyers will go in there and say what it really means is we're asking questions and getting answers in an effort to pick a fair jury. But really what both sides are trying to do is pick a jury that's sympathetic to their side of the story. So as part of it, you're also educating the jury a little bit about what the trial is going to be about. And if you have a real issue with the trial, that's your time to start asking the jurors, because if somebody answers and says, oh, I have a problem that you don't have DNA. Oh, I have a problem that you don't have this. Or I believe that everybody that accuses somebody of rape is telling the truth. There's no reason. Why would they lie? Those are things that you find out during that voir dire process. So it's a really important component, but it literally just means to speak to the jury and ask them questions.
Well, as a defendant, there's a couple of decisions that they make. One is whether they're going to go to trial or not, and I guess the other one is whether or not they're going to testify. What decision did your client make, and how did you come to that decision in terms of whether he testified?
So we believed from the start that he was most likely going to have to testify for a couple of reasons, because like I said, it was a he said, she said case in this. So if they put her on the stand and then they didn't hear from my client, even though they're not supposed to take that into account because he has the right to remain silent, and the judge said about 50 times that I can just sit there, we don't have to do anything, and the state has to prove the case. However, in this case, we felt it was important that he explained some of the things that he did not explain adequately during his confession or his statement to the police. The other thing was that the details were consistent with that statement that he made about the consensual sex and all the details. And then we felt it was important to put him in front of a jury. Now, even right up until the time where he took the stand to testify, we were still going back and forth about whether we really, really needed it, especially after half the charges had dropped off. But I was also putting up an intoxication and mental illness defense on the aggravated battery, which could have dropped it down to a misdemeanor. And we felt it was important for him to testify about how intoxicated he was as well. So with that, I put him on the stand. But most attorneys will tell you that they will not put their client on the stand. It's almost universal. They'll tell you, don't do it. Too many things can happen. For us, it went very well, but there was also a lot of prep work involved in that in terms of making sure that he understood only to answer the questions I asked him and not just go off on a tangent. So it worked out well for us, but it is a very difficult decision for attorneys and clients to make.
And I guess I'm going to start wrapping up here, but our people are going to want some advice, particularly if there's listeners who have charges pending. And when you're making this monumental decision about to accept a plea or to go to trial, and we've gone through a whole litany of considerations, but what would you tell them to do as succinctly as possible to help make that decision so you won't have as much buyer's remorse?
So the first thing is, if you are in a position to hire an attorney, make sure that attorney actually understands the charges and sex charges and what is required for proof, and also make sure that they understand registration obligations. And then the next thing that I would tell them is, for me, and some attorneys will never ask you if you did it. I ask my clients every time. I want to know the whole story so that I can formulate a theory about what we need to do in a case. So be honest with your attorney, as honest as you can be. Even if it's bad, your attorney is not there to judge you. Your attorney is there to figure out how to mitigate any damage if there is. Like, for example, if you made a confession and you really shouldn't have, but tell them about it so they can deal with it and make an adequate assessment of the case. But it really, really comes down to picking an attorney. Some attorneys will tell you, oh, yeah, I'll charge this much, but they always intend to plead the case. So ask your attorney, I might want to fight this. I might want to go to trial unless there is a really, really good plea offer. Are you willing to take this to trial? And ask them from the start, because if that's what you want to do, and I mean, there's so many considerations, Larry, as you pointed out, as to whether you take a case to trial or take a plea. For example, if the state offers a plea and there's no jail time and you can get a conditional discharge in New Mexico, which means you do not have to register, that might be worth not going to trial for. But in some of the other cases where they're like, no, you're going to plead to this charge and then you're going to have to register and then you're going to be on this indeterminate parole, that might be a good enough reason to take it to trial. So a lot of considerations, but first and foremost, make sure you're honest with your attorney and that you pick an attorney who is well-versed in cases like this.
Well, I would add to that. I agree with that. I would add to find out how many trials they've done in the last couple of years, because you'll find out that very few attorneys have that are taking large sums of money, because they'll tell you, yeah, I'm willing to go to trial. And then magically, as you get close to the day of reckoning, they'll tell you really ought to plead this out. So ask them how many cases they've tried in the last year or the last 2 years. And if they don't have any recent trial experience, I would be leery of going to trial with someone who has not done a trial. I mean, don't you have to keep your trial skills sharp by actually doing trials, Ashley?
Yes, you do. It's not like riding a bicycle and you don't do it for a few years and then you come back. It's actually difficult. You forget a lot about it, a lot of stuff, and then the rules of evidence change. They're not supposed to change that often, but they do. You have local rules. So also make sure your attorney is practiced in front of the court that you're actually in, because there are often local rules and customs that if your attorney doesn't know how to do it, they're going to be at a disadvantage. So absolutely ask those questions. Vet your attorney very, very well before you give them a single dollar.
And they will tell you that they have done trials. But if you haven't tried a case, give you an example in DWI. When you started practicing 25 years ago, DWIs were handled completely different than now. So if you had not done a DWI trial in 25 years, you would have not a clue if you hadn't stayed abreast of all the changes in terms of the law and how we handle DWIs now, because what you do 25 years ago is out the window. I mean, would you even take a DWI case? But would you even take a DWI case now? It's been so long since I don't think when you were at the 13th, you didn't do DWI prosecutions, did you?
I haven't done them in so long, and then I got one recently assigned to me, and it wasn't because it was a DWI. There was another charge, but I got the other charge dismissed and have to plead them to a DWI. And the poor client asked me, they said, well, what do I have to do as part of the DWI? And I had to turn to luckily there are a ton of people who just do DWI. in New Mexico and say, what do they have to do? And I looked at the statute, but yes, you're absolutely right. It would have been different if it was going to go to trial.
Ready to be a part of Registry Matters? Get links at registrymatters.co. If you need to be all discreet about it, contact them by email, registrymatterscast@gmail.com. You can call or text a ransom message to 747-227-4477. Want to support Registry Matters on a monthly basis? Head to patreon.com/registrymatters. Not ready to become a patron? Give a 5-star review at Apple Podcasts or Stitcher. Or tell your buddies at your treatment class about the podcast. We want to send out a big heartfelt support for those on the registry. Keep fighting. Without you, we can't succeed. You make it possible.
So, well, I want to tell you I really appreciate you coming in here Saturday evening on very short notice and spending some time with us.
Hey, Larry, before you dive there, I've got a couple questions from listeners.
Sure, I didn't realize that.
So first one is from Michael. It says, question for Ashley. Having been a prosecutor in South Carolina where I was sentenced, I was told that prosecutors were mandated by the Attorney General to maintain a 95% conviction rate or they will lose their jobs. What is your opinion on something like that, Ashley?
I think that's completely wrong. Not that that is wrong that you're saying that that's what they require. I just think ethically it's wrong.
Okay.
And the reason I think ethically it's wrong, I've said on the program before, is that prosecutors take an oath to uphold justice. Justice does not mean getting convictions. Justice does not mean prosecuting every case. Justice means looking at every single case individually and determining what is best and balancing the rights of the accused with the rights of the public.
All right. I think that covers that one pretty well. And then Paul asks, it says, at what point should they stop interviewing you? During mine, I asked for a lawyer 7 times. They even wrote that in the statement a few times. They either reworded the question or went on to the next one. And he said, then follow up, he says, I was scared to make a bad decision. I figured asking for a lawyer would stop the interview. I didn't know the law, so I thought they were doing right at the time.
No, they're supposed to stop the interview immediately upon you asking for a lawyer. In fact, my client in his interview in this one mentioned that he might, about an hour into the interview, I might want to speak to a lawyer. And the officer said, okay, we're done. He said, no. I didn't say I wanted a lawyer. He said, nope, it's enough that you even said that. And that's how they're supposed to handle that.
That's sort of what I thought. So then, and I think his case happened in Wisconsin. I don't know that jurisdiction even matters, but I'm pretty sure that's where that all went down. Is there any follow-up recourse that somebody would have like that? Does that call into question their case?
Any of that should be a motion to suppress because there's clear case law on your right to counsel and your Fifth Amendment right, and that is definitely here, I don't know about in Wisconsin. I can't speak for other jurisdictions, but that would be grounds for suppressing the whole statement. The second, anything after asking for a lawyer, but if you ask multiple times and they continue to talk to you, the entire statement would probably be thrown out. But that's about the only recourse there is.
Yeah, now that doesn't make the case go away in all situations because they may have enough evidence despite your confession. That would just be the icing on the cake. But it could severely damage a case if they had a weak case and you did a confession, and that's usually when they will push so hard for confession is because they don't have a strong case. Remember this: if they need you to confess, they don't have a strong case. If they've got an airtight case, they can tell you we're booking you into jail. Have a great day. We'll see you at trial, because they don't need you to when they say things are going to go easier, it's going to go easier on them to convict you. And I remember a case, this goes way back to ancient history, and nobody cares about it, but I do. There was the contrast in jurisdictions, but I'm trying to illustrate a point rather than just the fact they have a good memory. But the point is the contrast and how they do things in jurisdictions. There was a high-profile case in Boulder, Colorado, in 1980-81 in that era, and the suspect had left Boulder and gone to Florida. And Boulder detectives went to Florida to interview them, and they were assisted, of course, by the Florida detectives. And Boulder actually went by the book. I've commended Alex Hunter, who was district attorney, and the establishment there many times. And Boulder immediately did what they said, we're done. But Florida said, nope, we ain't done here. We got a few more questions. And they kept pushing, and that was the case of Tattoo Bob Landry. And the district judge in Boulder suppressed the statement made by Landry because he asserted his right, and Florida continued the interrogation. That's the difference between the jurisdictions. Boulder knew better. Florida had been doing things the old way that they'd always done it, and they said, we gonna keep going.
Larry, did you go back? What was this person's name?
Tattoo Bob Landry.
Okay, I just wanted to make sure I heard that right.
So, well, you can Google it. It'll probably come right up.
I will pass on that for now. I have enough stuff going on over here with all the technical challenges I'm putting.
Yep. Yeah, he got suppression of his statement. Ultimately, they convicted him because they still had a pretty good case. So the point is, your case won't necessarily go away, but you don't want to strengthen the case the state has against you. That weakens you in plea negotiations. It does not make you have a stronger hand by giving them a stronger case. It does give someone a stronger hand, but not you.
Okay.
Right. And it's funny that you should say that, because of what actually came out in the trial was the officer explained his interrogation techniques. And he said the first part is open-ended questions, just trying to see how much information that my client would tell him. The second part was him actually bluffing, and he admitted that he was completely dishonest about how much DNA they had and what evidence they had to try and get my client to confess to more. So the moral of that story is, don't believe that they have anything. And Larry is 100% right. If they have to push that hard for confession, they don't have it, because otherwise they just put you in jail and they worry about it later.
So, well, Ashley, with the thousands of listeners we have, someone may want to contact you. And do you want to give people some method to contact you? Because there will be questions, and perhaps maybe someone might want to retain you, because in addition to the famous lawyer up in New Jersey, Connecticut, that got an acquittal a year or so ago, you have a acquittal now on similar charges. So you have joined that club of elite attorneys. So how would they contact you?
Sure. Anybody that wants to reach me, they can reach me at Ashley, ASHLEY, at Zenlaw, ZENLAW.net.
Okay, well, thank you. Thank you so much, Ashley, for being with us, and congratulations on behalf of the audience, in particular for me, saying this is the business I'm in. It's a fantastic win. I don't know anything about the case, but I know that it's a lot of stress to put on a trial where the stakes are so high. So kudos to you, Ashley.
I guess we can we move over to the New York Times article? Texas police officer charged with murder in fatal shooting of a black man.
Sure, that shouldn't take but a moment, because it's one of those where I don't know guilt or innocence. I know that the Texas, what do they call it, the state authorities? I forget the name of their state police. They've sought charges, and the guy's been arrested, and he's entitled to his presumption of innocence and his due process. But at least there is an accountability happening. He is being held to account for shooting the person in the back, and the person was just calmly walking away, as I understood it. They didn't choose to be engaged with the police, and they decided to walk away.
Oh, all right. This is the Texas Rangers.
I don't see a problem with that. Do you?
No, not a problem with that at all. I think you should always discharge your weapon into somebody's back. That seems like that would be the best way to approach it.
So, but yes, at least. But see, this is all the people of my persuasion want. We want good, clean, thorough investigations. And we want accountability where there is questionable behavior, that a real investigation takes place, and that if charges are appropriate, that they face charges and that they be held accountable. Then trust is restored in the police when you know that the police don't have a license to do anything they want to do. That's all. That's all we're asking for.
I'm with you. All right. Over at Forbes, IRS must pay $100 million worth of $1,200 stimulus checks. Judge orders in prisoner's lawsuit. Does this roll back to the previous stimulus, the CARES Act, where a bunch of our people and people in prison didn't receive funds?
That is correct. We talked about it on an episode that I can't remember the number, of course, but we talked about whether or not, and this was a case where there was nothing in the statute that precluded them. And we talked about, like in the Social Security Act, a person who's in custody for being convicted of a felony. While they're in custody, they don't receive Social Security. And then on one previous stimulus payment, they specifically put in the act that people serving time were excluded. They didn't do that in this. They might have intended to, but they didn't. And the IRS decided on its own from administrative inertia, actually not inertia, it was actually, they had plenty of inertia. They issued the directive to the prisons to intercept these checks and to prevent people from receiving these payments. And that's where the problem, because the law isn't what you would like it to be, the law is what it actually was. And there was no exclusion. These people may have been in prison after they had earned the stimulus, and you didn't really earn it, but you know what I'm saying, they're entitled to it. If you worked all the way up to April 2nd, 2020, and you were in prison on June 14th when they sent your payment out, why would you be excluded? Unless there was a specific exclusion in the law. There wasn't. This is the correct ruling. I would expect the Trump administration to appeal it, because it's very popular to say that we're not going to give these freeloaders money off the backs of the taxpayers, and they'll probably try to overturn the lower court ruling. But for the moment, it's a great victory.
And then over at the Brennan Center for Justice, Amy Coney, God, I keep saying Comey, I know why. Amy Coney Barrett's judicial record in criminal justice cases. And I did not get a whole lot of chance to read this, but I think that you have a pretty... a short way to sum this up.
Well, as we've learned, and as I've said, we don't know what they're going to do when they're on the bench. Occasionally, people surprise us, and we had a surprise with an appointee under George H.W. Bush with Zanunu's recommendation, and we ended up with, his name's escaping me, but we don't know what they're going to do. But what we do know is based on this judge's writings that she's not particularly sympathetic to the rights of incarcerated. But it looks like on gun rights, she's very strong, which will be nice for. Only problem is our people are not allowed to own weapons. That's the only problem with that. And it looks like she has had some sympathy for the drug enforcement's overreach on a search warrant. So it's a mixed bag on most everything. When it dealt with criminal defendants' rights and dealt with the rights of incarcerated, she's on the wrong side. But it looks like if you're a gun supporter, she'll be just fine for you. And it looks like also that if there's issue of police overreach into a search and seizure, you might get some consideration from her. But we truly don't know. It's one of those things, if we were doing the proper vetting, we could actually pose those questions. But under these circumstances, nobody wants to vet this person because she's already been vetted for the appellate court. And now we should just rubber stamp and put her in the Supreme Court. That's kind of the attitude.
I understand that as well. That seems to be the plan. And then courthouse news, California justices take up extent of voter-backed parole expansion. I don't have any idea what's going on here, but you're going to explain it.
This is one of those propositions where I believe that specifically the language of the law did not carve out the PFRs as an exception, but administratively they did, Proposition 57. And if they did carve out, it wasn't a complete exception for all PFRs, but the way the California Department of Corrections is interpreting it is that anybody who has to register they don't get the benefit of Proposition 57. So to the credit of Janice Bellucci and the Alliance for Constitutional Sexual Offense Laws, Janice brought this case against the California Department of Corrections and Rehabilitation, and we're going to find out if you can administratively exempt people from the law. Again, this is similar to what was done with the checks. You can't do that. The law is the law. If the legislature had wanted to have everybody that was required to register be not entitled to the benefit of 57, they would have written that should have gotten in the proposal. But Jerry Brown vowed that nobody would that people who had sex offense conviction would not get any benefit from early parole. And by God, they have stuck to what Jerry promised. That when the voters passed this, he said they ain't gonna get no early release on my watch.
Well, there you go. And
when this case is over, I'd love to have Janice explain all the nuances. But I'm glad she's doing it, and I'm pulling for the success, and maybe the Supreme Court of the state will say, sorry, the Department of Corrections cannot do what they're doing.
And almost finished, Florida, from the Tampa Bay Times. Florida ruled felons must pay to vote. Now it doesn't know how many can. Florida's Amendment number 4 was supposed to restore the voting rights of up to 1.4 million felons. Instead, it might be America's biggest case of voter disenfranchisement. So 2014 voters in Florida voted to allow felons to have their voting rights restored based on an amendment. God, Amendment number 4 would have to be almost like Florida initiated their constitution. Okay, well, then we have Amendment number 4 that had to follow suit almost immediately after that prevented felons from voting. Well, I guess in lieu of all the technical problems, we will close out the show. But before we let everyone go, I would like to thank our new patrons. We had Bradley has increased his patronage, and thank you so very much. And then we also have a new patron, Adam, and in being very generous. Thank you so very much. Really, really appreciate it. And I think we're pretty much done then, Larry.
Well, how do people support the podcast and contact us and leave questions? We got to tell people that for the very least.
Of course. Registrymatters.co is the website, and the phone number that I used to talk to Ashley this evening is 747-227-4477. You can email us at registrymatterscast@gmail.com. And of course, Larry, the best way to support the podcast is what?
Patreon.com/registrymatters and do your gross pay.
I thought we were going to have people take out second mortgages.
Well, that'll come next week.
All right, then. Larry, as always, thank you so very much. And I really appreciate that you are here to share all of your insight and wisdom.
It's my pleasure.
That is why I am here.
Good night, Larry.
Good night.
You've been listening to FYP.